Thanks for attending. Exciting topic we have. I get a lot of calls on this in the office, and especially, I don't know what's going on this year, but I'm routinely getting calls and working with folks and setting up healthcare practices of all different varieties. And so we decided to put together a series. You may note we did something similar a month or two ago. We've got this month's presentation on building a healthcare practice in Florida. Please note, this is educational material. It's not legal advice. If you want legal advice, please call separately and make an arrangement to speak with me or somebody in my office. With that, I'm going to jump in. And what we're going to talk about today is the first steps, the things that you should be thinking about as your essentially your threshold idea if you decide you want to start a healthcare practice in Florida. And it's not running out to file the entity or get a license or do any of those other things, sign a lease. Hopefully you're not doing that or hiring folks. This is basically figuring out what are you building. The first decision is that you define your practice model, figure out what you want to do for your practice, and then we determine from there how the entity should be set up, what the licensing exemptions or applications are, and we work from that piece. Uh, I'm going to be presenting over the next several months multiple seminars covering these topics to take you the steps from step one through multiple steps. If you saw a seminar I did a couple months ago, I talked about essentially 8 major steps you have to look at and take in forming a healthcare practice. And this is step one. This is when it all starts. Uh, you have situations where clinicians, physicians, and other folks who work hard to become licensed professionals in their practice, and they're clinically excellent, and they decide, okay, I want to do this on my own. What comes next? Do I need an LLC? Do I need a PLLC? Do I need a license? We're going to talk about some of those questions and answers today. We're going to focus, in this one time that we have together, we're going to focus on the what and the why. We don't have enough time to dig into the details of how you do all of this stuff, but this is going to give you an overview, and you should get from this a checklist essentially that you can work from in the presentation materials so that you understand what the first issues you need to think about are as you go into the building process of your own practice. Who's this for? Uh, there's a wide range of professionals and entrepreneur types who can benefit from the information I'll talk about today and in the multiple seminars that follow as we continue this series. Obviously, physicians who are considering independent practice, autonomous practice, advanced practice registered nurses who now have autonomous practice rights in Florida for the past several years. That means you can own your own practice and run that practice without being under the supervisory protocols of a physician. Note, however, that if you venture outside of your, and we'll talk about this a little bit more as we go forward, if you venture outside of your uh, what your practice authorizes you to do, which is general practice, and what the autonomous practice statutes authorize you to do as far as what you can do without needing supervisory or supervisory supervision from a physician. If you get into other areas such as aesthetics, that's an area you may not be able to practice autonomously. We'll talk about that. Uh, Obviously, advanced practice registered nurses and physician assistants who are operating under protocols can own their own practice. I have clients that are in that situation now. They have their own practice, but they work under a physician protocol. If they work in a clinic environment where it's licensed, there may be a medical director. Medical directors, or if you're a physician who's been asked to be a medical director and been presented with that, it's an opportunity, but it's also an obligation and a duty that comes with being a medical director. You can benefit from the material that we're going to talk about today. And anybody else who wants to open a healthcare practice, I've been contacted by folks in Florida and outside of Florida who want to open up a practice, and they're not licensed physicians, but they realize that in Florida, you don't have to be licensed to own a healthcare practice. You can do it as long as I said you don't have to be licensed. You don't have to be individually licensed as a professional. You don't have to be a doctor or a licensed physician to open the practice and own that practice. You can do it if you set up the proper business model with the licensing regime that we have in place in Florida. So the first question we're asking here is the practice model. What are you actually building? And this is going to form the foundation for everything else that you do as you go forward and start to put this together. And our instinct initially, I mentioned in the beginning, is we open it, and you go on Sunbiz or you ask somebody to do this, you set up the entity, you say, okay, I'm going to start building the practice. That you can do that, but it's not really the proper first step. Even the entity organization, is it going to be single member? Is it going to be multi-member? Is it going to be an LLC? Is it going to be a PLLC? Do you need that? What are the implications of doing it? Here's a fact for you. You do not need to be a professional corporation or professional limited liability company in Florida to own a medical clinic and operate the clinic, either licensed or not licensed as a professional. It used to be that way. It is that way in some other states. There are some other implications and restrictions with having a PLLC or a PC. In Florida, generally, we recommend just the LLC regime, but how you set that up matters. If you're going to be operating under the exemption from the licensing requirements, that's going to look like one structure. If you're going to be operating in an environment where there's going to be multiple owners, or you're going to have a medical director and get the license, that may look different. There's controlling interests to think about. Anybody with 5% or more ownership interest will have to go through a background check in Florida. These are all your foundational questions, the stuff that you should ask before you even go into starting to form the entity. And then the practice model, what you're doing, what type of practice are you going to offer? Is it going to be a general practice, pediatric practice? Is it going to do aesthetics? Is it going to do weight loss? We're seeing a lot of hormone therapy practices, hydration, health practices, med spas. These all will generate different paths for you to follow. You're following the same general path, but there's going to be different questions and answers along the way, different statutory regimes that you're subject to. And all of these questions you need to answer in the beginning, or I believe it's best to answer in the beginning before you dig into the actual details. It also will, those types of practices will inform on your risk profile and credentialing requirements, how you're ultimately going to get patients, how you're going to get paid. Lots of people do this because they love it. I do law, I do mediation. I love it. I'll probably do it forever. I don't ever see a retirement date. However, it's also the way that I feed my family, and without clients, it's very hard to continue to operate in this business. So I'm thankful for that. And anytime you're starting a business, no matter how much you're doing it out of passion, you should be thinking about the ultimate goal, being at least part of that being, how am I going to generate business, patients, and how do I do that legally and within the regulatory constraints that we are faced with in healthcare? How do I do that, make it profitable, make it enjoyable, and how do I plan to keep the lights on, make this a good investment of my time and my resources, as well as making it legally compliant? So some questions that you're going to look at as far as what the what the structure may look like. You could have a solo practice or a group practice. You could have cash pay or take insurance. If you're going to take insurance from third-party payers, are you going to take federal insurance? That brings in different requirements and implications. If you take Medicare or Medicaid, TRICARE, you're going to be subject to the potentially the Stark law and the federal anti-kickback statute. Even if you're not subject to federal anti-kickback statute, Florida has its own versions through the Patient Brokering Act and the fee splitting statutes. Your clinical scope, as I mentioned earlier, are you going to be a specialty clinic? Are you going to be a primary care practice? Uh, what type of delivery mechanism? Is this going to be through a regular office environment, a brick and mortar, or are you going to do it through telehealth? If you're going to do it through telehealth, you need to have specific consents and disclosures for telehealth and have a proper and compliant platform for that. You might have a mobile practice. Some folks that's becoming more and more popular, especially for specialty practices. And you can operate in a hybrid type environment where you're using a little bit of each one. I want to point out, one regulatory issue for telehealth. I have some clients who deliver a lot of telehealth services and have highly specialized practices. Note that the law, and this is pretty consistent across most of the states that I've looked at, the law that applies, including as to your license, isn't where you are, it's where the patient is. So if you're a Florida practitioner and you're engaging in telehealth services and you're providing services to somebody who's in New York or Texas, somewhere else, the general rule, the law is that you have to be that the law of that state where the patient sits is the law that applies, and you have to be licensed in that state. In that note, I have some clients who have gone through the process of getting licensed in multiple states and through the interstate compacts have become licensed in all 50 states. That's one possibility. I have other clients who first see the patients in Florida and then they do follow-ups through telehealth. That's a little bit more of a gray area. So not enough time to dig in. That's its own issue, but just be aware if you're going to do telehealth, you still have to make sure that your patients are in Florida or you account for that part of the statute. Your patient mix, the geography, where are you going to open it? Where are you going to serve patients? If you're going to be mobile, how far are you going to travel? If you're not going to be mobile, you're going to see folks in the office, they come to you. Where are you going to set up? If you're leaving another employer or a hospital system or somewhere else where you had an employment agreement, are you subject to a non-compete? Do you need to account for that? These are all questions you should be answering before you even start diving into setting up the practice. Then the final piece, or one last piece to consider, is what services are you going to offer in the beginning and what might you add later? For instance, you may start as on day one, you might be a primary care practice and you cover just primary care, chronic disease management, basic in-office services. And then later you may add additional services that support that, such as maybe hormone therapy or weight loss or something else to tack on. So sometimes people start with one practice, get that going, get the foundation under you, and then move into something else and then branch out and expand. All right, so let's talk about some of the specific issues that apply to, and we'll take a moment. Some issues are going to apply specifically to non-licensed clinicians, and some will apply to physicians. I had a special slide here for APRNs and PAs. And the big reason here, what I want to point out is that uh, generally these folks traditionally you've had to work under supervisory protocols from a physician who's responsible for your practice, and you file those documents with the Department of Health and you keep that current, and I prepare those for clients, and you can operate your practice essentially independently, but the physician who signs off takes on some responsibility. Normally there's some type of agreement in addition to the protocols. There's an agreement between the physician and the APRN or the PA, and there's a payment arrangement, but there's a level of responsibility that also applies for the physicians. And then in a couple of years ago, what we saw was the adoption of the autonomous practice statute. And I think that is subject to a little bit of misinterpretation because for that statute, yes, APRNs are authorized to work autonomously without the supervision of the physician protocol. But it's limited. It's not, you can't do anything with that. It's really designed, and the purpose behind it. It talks about this, the statute talks about general practice. And if you look at the legislative history, the reason that law came to be was because of a shortage of general practice services in healthcare. It wasn't because of a shortage, for instance, of weight loss management or aesthetics or hormone therapy. Those are kind of the big ones that I'm seeing right now, a lot of. So then the question comes up, well, okay, can I do that independently and work autonomously? And I think that's where there's some gray area. So that's one of those things where maybe you want to do a deeper dive before you go down that path and talk to somebody who has knowledge. Look at the statute, look at the history yourself, or talk to a healthcare attorney who can walk through those issues and figure out how to keep you on the right side of even that gray area. All right, this I like. This we did when we started years ago when we were starting our law firm and tried to define what we were going to be. And whenever you start a business, this is a good practice. And so I wrote it in here when you're starting, when you're designing what your practice model is going to be, you want to be able to describe it in writing so that an outside reader understands it without follow-up questions. If you can't do that, then you probably haven't fully defined your practice, and it will bring about other questions and maybe some corrections and make things more difficult as you move forward. So this here, I have to comment, it's the paragraph that you can write. It's not just your sentence or your one or two sentence mission statement. It's really a paragraph that defines your practice. For instance, you might have something that sounds like this, that you're a primary care practice accepting Medicare and commercial insurance. You're physician owned as a solo primary care practice in the Orlando area, owned by you, Dr. Whatever your name is, Dr. Smith, who's a board certified family medicine physician. The practice provides preventative care, chronic disease management, and acute care visits for adults 18 and over. And that's the beginning of your what your paragraph sounds like of what your practice is going to be. Then you could add to that and say, after so many months or after the practice gets going, now we're going to add this additional service. We're going to add maybe weight loss management and then go through the same process. Who are your typical clients going to be? Is it going to be cash based or are you going to try to get insurance involved? How are you going to acquire patients? What's the geographic area? So that's a little bit of a homework assignment. Presumably, folks who are joining us have an interest in starting a healthcare practice. Try that. Sit down and write out a paragraph that answers the traditional questions of who, what, when, how, and why, and put that information together as a foundation as you move forward. Now, the model that you come up with, what your practice is going to be, that's what then serves as the foundation and drives every decision after you come up with that foundational paragraph or that foundational description of your practice. So let's talk about that a little bit. Now we're going to go into the question of entity and ownership. This is probably one of the most common questions that I get as an attorney. A lot of it has to do with sometimes people ask, can I do this with my license? But I think there's a lot of assumptions that happen there, and people ask, okay, what type of entity should I be? And I've represented folks who have practices or businesses that have representation in several states. So they may operate not only in Florida, but outside of Florida. I'm also licensed in Nevada. So I've looked at the laws in other states for clients here and for clients who have a multi-state practice to see what the differences are just in entity formation. And it's really interesting if you look at the requirements from one state to the next, whether or not you need to be a PA or a PLLC will change depending on the state. In Florida, our go-to is generally going to be the LLC, but whether that's a single member or a multi-member, whether you set it up as a holding company and subsidiary structure or just single owned, if the holding company, if you do that, it's going to be Delaware, going to be Florida. These are all things you need to think about, and you have to always consider that if the practice, whether the practice is going to be need to be licensed under the Healthcare Clinic Act, and you have to go through ACA for that licensing. That's in Chapter 400 of the Florida statutes. Uh, Whether or not the practice has to be licensed or whether you fit into an exemption, and that exemption generally exists for physician-owned practices, but if you bring in a second member or other members to practice, other investors, it can affect that ownership. Now you may have to go back and get a license, except there's exceptions to that. You can generally have a practice where you have the licensed clinician and a spouse, or a licensed clinician and certain relatives, and that doesn't cause the exemption to no longer apply, but you need to be very careful with how that gets set up. And these are all the considerations that we take account of when we're first starting to set up the practice. Another issue is if you are a single member LLC, from a legal liability and asset protection standpoint, there are issues with a single member LLC where there's not as much protection as exists for a multi-member LLC. So there are sometimes reasons to bring in a second member if you can do it, and you have to balance what's the complexity as far as the licensing requirements are, what's the complexity as far as adding additional members if they're going to be categorized under the licensing requirements as a controlling interest. And if you're going to go for the exemption, how do you set up maybe a multi-member LLC and still fit within the exemption and not ruin that? And then those same considerations come back when we're talking about insurance and credentialing. So just these are the what and the why. You've gotten some materials. I'm throwing a lot at you. You've gotten materials in connection with today's webinar, and those materials cite the statutes and certain administrative codes in Florida where you can take a little bit of deeper dive. Of course, I always welcome any questions. And if you have questions, by the way, while we're doing this, throw them out or jot them down at the end. We'll take some time for questions. I'll be happy to field that. All right, I foreshadowed this a little bit already. This is the wholly owned clinic exemption from ACA licensure. And everybody who's considering opening up a healthcare practice in Florida, you have to consider this question. Uh, are you going to be required to get an ACA license? And what does that look like, both from a time frame standpoint and the information you need to apply? Here's a little preview of that if you haven't looked at that yet. If you need an ACA license, which is generally going to be required unless you meet the wholly owned clinic exemption, That ACA license, they're going to require a lot of financial information. You're probably going to want a healthcare familiar accountant to be involved in that process with you. And they are also, ACA is going to require anybody with a 5% or more interest to undergo a background check. There's also additional requirements when you do the licensing. And the license timing right now, we've helped people get licenses. I have many clients go through the process. We typically don't do it directly because it's not very efficient to have the lawyer doing the licensing. We can assist as questions come up. There are consultants that I work with, and those consultants are excellent to work with to shepherd you through that process. What I'm told right now is that process is probably somewhere around 90 days. Expect 90 days for the licensing. Don't hold me to that, but that's just the general expectation. So if you're thinking about going down that path, you'll need the entity and you'll need to start the licensing process very early on after you answer the questions we're talking about today. Now, if you need the license because you don't fit into the wholly owned exception, you will need to have a medical director. And the medical director has specific defined duties in the medical director role and responsibilities and liabilities. And most of those are found in the statute and the rule that I've cited here. If you go on some old YouTube videos, you may find I did a whole separate, I've done at least one, I think maybe a couple in the past, webinar presentations on the role of the medical director in Florida. There are some limitations and some constraints. Generally, you can only, a physician can only be a medical director for no more than 5 practices. There's some geographic constraints there. And here's something else I want you to be aware of. In most other businesses, if you're operating a hobby store and there's a slip and fall, or you're operating a grocery store and something happens in the store, the plaintiffs don't go after the owner, generally speaking. They may try and go after the business operator, whatever that is, a corporation or an LLC, and maybe they try and go after the owner of the premises if that's separate, but they don't go after the individuals who own it. They don't go after the manager because somebody slipped and fell on a banana peel in the produce aisle. In healthcare, it's different. I do a lot of mediations in the healthcare space. I do mediations that involve conflicts between payers and the providers, and these are billing conflicts. These are usually pretty high value situations. We're talking millions of dollars in dispute where there's allegations maybe of improper billing, uh, not services that are not medically necessary, services that maybe violate certain statutes such as the Patient Brokering Act, or clinics that build insurance or some third party. It could be either health insurance or it could be through the PIP statutes we have, and the clinic wasn't properly licensed. In several circumstances, I have, as a mediator, handled cases where not only does the company, does the clinic get sued, but the individuals. Healthcare is different because the individuals, the owners, the clinicians, and the medical director will get named in a suit. And the medical director is always going to be named because the medical director takes on liability when you sign up for that role. So if you're a young physician, maybe finishing up residency and just get your career started, and you have the opportunity to become a medical director, definitely consider it, but understand what you're signing up for and understand that that role requires you to show up and be responsible for the records, for the billing, and for other issues. I see this also among older folks who are approaching retirement who do the same thing. You have specific duties and responsibilities that you need to be aware of. And if you end up just in a figurehead role, which is what the allegation typically is, it's just a medical director who's paid to use their name to get a license. Not only do you have potential liability issues in the clinic, that triggers potential anti-kickback statute and other concerns because you're being paid to help generate patients in an environment where you're actually not providing services that are fair market value. A lot of implications there. We just want to walk that line the proper way. It's not overly complicated. It's not something to worry about once you get running, as long as you're doing things right. But that's why we talk about setting up correctly from the beginning to make sure that once you get operating, you don't have to worry about that coming back after you. All right. So additional concerns that you have as you're setting up the practice. I want to make sure I covered. I apologize. I'm just jumping back here and then. All right. Credentialing. This is a big issue. If you're going to be a cash pay clinic, that's one issue. I want to talk about a couple issues there. If you're going to accept insurance from third party payers, whether that's uh, federal programs such as Medicaid or Medicare or private third-party programs, you need to be aware that there's a process for that. And you typically have to go through your practitioner credentialing to get your NPI and your quality care assignment, and you have to re-up those attestations for the Council on Affordable Quality Healthcare requirements. There's specific requirements where you put the information into a database, and the practitioners know this, and then that information gets maintained. So you don't have to fill out a full application each time, but you have to reattest to that information every time you go to credential with a new provider. The individual credentials, who's providing the services, and the practice credentials. So it's two different credentialing. Well, actually, let me back up. It's two different NPIs. It can be one credentialing process, two different NPIs, your National Provider Identification Number. You bill the person providing the services bills under their personal NPI to indicate who provided the services, the time, and the description and so forth that match the records. And then the payment generally comes to the practice NPI. So you have two different NPIs. The credentialing process is different for whether it's a practice or an individual. Some different insurance companies, and depending on the practice, will have different requirements for how additional individuals are added. There are also, in some circumstances, and I think there's some in South Florida for particular practices, maybe home health care, and it was something else I encountered recently. There are situations where the insurance companies are not taking on additional providers right now. There's a hold, or there's a stay, and you can't get into the system. So you need to be aware of that, depending on what you're setting up. Does your practice qualify, and can you get on the list essentially for the insurance companies that you want to provide services for and take insurance from. So that's a long process. You need to get the credentialing process started very quickly because you can be looking at 180 days in some circumstances to finish that. Uh, Staffing issues. Again, level two background screenings are going to be required for anybody who's touching records or dealing with patients. And I mentioned earlier restrictive covenants. If you're hiring somebody or if you're venturing out on your own, this is something we see almost every contract I look at in the healthcare space for any type of provider, be it a physician assistant, nurse, physician. That contract usually has some level of restrictive covenants in it. And if you are subject to those, you need to be aware of what those requirements are if you go to make a move. And if you're hiring somebody or bringing somebody on as an independent contractor or teaming up with somebody or are going to do this yourself, you need to be aware of whether those restrictions apply. Because the last thing you want to do is get your practice running, get somebody in to help you, and then get a demand letter from an attorney that says, hey, this person's subject to a restrictive covenant and you're not allowed to hire them. Now you're dealing with a totally separate issue you really can avoid as long as you do your due diligence on the front side. Marketing issues. As we go through this whole series, we're going to talk more about this in later months, but marketing in healthcare is not like marketing in other businesses. You can't just pay on a pay per patient or pay on a percentage of revenue basis. That implicates fee splitting, kickback concerns. There are federal and state regulations that restrict the mechanism, the way you engage in your marketing activities. And it makes sense. When I talk to people about healthcare in general, people have very strong opinions, I think as they should, in Florida and in the U.S. about our healthcare system. It's a political football. I'll just say for today's purposes, I think it could be a lot better in a lot of respects. That's not with respect to the providers, it's the system. But we have a payer system where you have one person who typically, a person or a company who typically provides the services. You have your patient population who receives the services, but you've got somebody else, you've got a third party who's often paying for those services. And it's either a commercial insurance company that, whatever they say, they're a for-profit company, or it's federal government or federal government tied in with the state government in the case of Medicaid, and so you have somebody else paying for the services. They are not looking for ways to drive up the level of services that are provided to patients. You get this question of whether services are medically necessary or not, whether it's a proper use of services. That's where the fights occur. When you understand that different formula that applies in healthcare that doesn't exist in many other situations, it starts to make sense why this is a regulated environment. It also starts to inform you on why maybe we have some of the problems that we do. And if you go with a cash pay type practice, maybe you avoid some of those issues. I do have clients that operate cash pay, they operate a concierge type practice, uh, but those have their own issues. Sometimes it's a little harder to get patients. It's a little bit longer runway to get that practice built up. And I do want to mention that there's a question in the licensing. If you have a medical practice providing medical services, but it's not clinician owned. And if you take insurance, obviously you're going to need to get licensed with ACA and have a medical director. What if you're cash pay? There's some language in the statute that talks about reimbursement, and that's been interpreted by some folks to suggest that if you operate a cash pay practice, you don't need to get licensed. That's a deeper question than I can answer today. I just want to make you aware of the fact that that issue's out there, and I don't want anybody to make any assumptions. Finally, your risk profile with respect to the services that you provide. A big one here is controlled substances. Regulated, you have to, for the clinicians, you have to have your DEA registration. And then in Florida, we have mechanisms in place where you have to, the provider, when you're prescribing certain controlled substances, depending on the classification, has to update the database. And the reason for that is so you don't get duplication of prescriptions, so that somebody doesn't go to one provider, get an opioid prescription for pain, and then go to two other providers and get the same thing. There's a limited number of days that those can be provided. So you need to be checking, make sure you're registered, checking the database, and then updating the database when you do that. Lots of steps involved. The clinicians are going to be aware of this, generally speaking, if you're already doing it. But all these things need to be a part of your outline as you start to build your practice. All right,
Let's
so you've
take a
done,
question.
yes, sir. Yeah, let's do the question.
Okay, so for professional medical services, when do you need to use PLLC versus LLC naming convention?
Great question. All right, thank you for that question. In Florida, you do not need to use PLLC. A PLL, so you have LLC is your limited liability company. PLLC is your professional limited liability company. The real difference there is that your PLLC is all licensed professionals that are into PLLC. So it has a built-in statute. And in fact, I haven't, the statutes were updated on the LLC. I'll say generally, anybody can use the LLC. You do not have to use the PLLC. There are some restrictions if you use the PLLC as to who can be a member. But generally, for our purposes, we use the LLC. The PLLC statutes refer back to the LLC statutes anyway, Chapter 605, and then we cover all the restrictions on ownership and transfer, and the control mechanisms for the LLC, who the managers are, how you manage the internal workings of the ownership through the operating agreement. So rather than relying on the statute, we focus on the operating agreement. And there's also a question I'll tack onto that. People often ask, should I be a corporation or an LLC? Short answer on that is we generally like the LLC, especially in healthcare. Both provide the same protection, PLLC, LLC, and the corporation all have the same protection for the owner as to what happens inside the LLC. If there's a liability in the LLC, assuming you're not personally involved, you generally have insulation from that. You have liability protection. The difference is in the ownership. If you own a multi-member LLC or PLLC, and you have an outside liability. Let's say you lend your car out to somebody, they go out and they get in a bad accident. You're the owner of the car, you get sued. That's the most common situation that I see, even among professionals. Loan out a vehicle, a boat, something else, you get sued. Your ownership interest in a corporation, your corporate stock, whether that's stock in Disney or Apple or stock in your own personally owned company, that's exposed. That stock is subject to attachment and a seizure by a creditor who goes through the proper mechanisms. An LLC, if it's single member, you have that exposure. Multi-member, you don't have that exposure because of the way the statutes are written. So hope that answers the question. Welcome any follow-up. PLLC, LLC, essentially the same mechanism. It's just if you have if folks who are not licensed professionals, you don't use the PLLC, use the LLC. Thank you again for that question. All right. So now we'll talk about our initial launch, you're getting ready, you're going to open the practice, and once you open and decide what you're going to do in the beginning, uh, you start operating. You've become you're licensed, obviously, or licensed through AUK, and you get credentialed. You have your insurances in place. Uh, you have your practice description that we talked about earlier, and now you could talk about services that you may want to add down the road. This is again, I mentioned earlier, maybe you have primary care, preventative care, and you defer things like in-house labs or DME dispensing. Uh, or aesthetics, injectables, weight loss, hormone therapy. These are your add-on services later. So you open up, get running, get the practice going, and then talk about, you could bring in another practitioner, add another physician or another PA or nurse practitioner, somebody who can provide services, maybe provide other ancillary services. You see practices that add, maybe therapies of different sorts. These are all the things that happen once you get the practice open, and now you define, okay, what's your runway look like now that you've launched? What is it going to look like as you go forward? What's the path to success look like? Uh, I put a special note in here again about the credentialing. I mentioned this earlier. 90 to 180 days per payer is what we're typically seeing. That's the feedback I get from the very well-informed consultants that I have worked with, and things that I've read. And I have clients that even, where we try to do, sometimes they put together the business, they rushed into it too fast. They come back. I'm working with somebody right now. They want to restructure. They don't like the way the business is structured. There's actually some things I mentioned earlier, weaknesses. They've got one in a corporation. I just don't like that as a long-term plan, especially if you're not practicing every day. If you're going to be an owner who owns the practice, but you're not operating day to day to see patients. I don't really like you being formed as a corporation because you're taking on unnecessary liability. The issue is, if once you start and you start operating, if you want to change things, even by taking your entity and maybe moving it into a holding company, which we do regularly, uh, and then you have the holding company that you own, or you put an interest in a trust, and then that holding company owns the subsidiary that practices, your ultimate controlling interest is you. You're the person who's responsible at either level, but ACA may consider that a change of ownership, and you have to go through a process. And then Medicare and other payers may consider it a change of ownership. And what I've run into recently is that there's private commercial insurance companies who consider that a change of ownership. And if there's a moratorium on bringing in new providers into that network, now they can't do it because of the moratorium, even though it's really just a change in form that would add protection. So I'm dealing with that issue right now, where we're trying to figure out how to do a restructure, but also deal with the moratorium. Because the last thing we want to do is do some legal work that we find out after the fact now screws up their ability to operate on a day-to-day basis. So that brings up another point: is when we do this stuff in our office, you should have a team. I'm a lawyer. We're a law firm. I do other stuff as well. We'll talk about, we're doing an education course that'll help people with this. That's not law, but I'm not an accountant. I'm not an insurance expert. I'm not a credentialing expert. There are people who do that, and we like to work with that team. And we encourage you, as part of the initial process, have the team in place. I'll ask my clients early on, new clients, who's your accounting professional that you work with? Let's make sure that person is signing off, so we don't do anything that triggers some weird tax consequence or an accounting issue. And we don't want to do anything that's going to put you into a situation where now you've got trouble getting paid from one of your providers. So we always want to be looking at all the pieces. It's the old adage, measure twice, cut once. Certainly applies to any moves we make from the startup to the follow through on operating the practice. All right, so what are some of the things that potentially go wrong here? The sequencing failure. This is the big one. Uh, you form the entity, sign your lease, and now you've got financial obligations, and you haven't started credentialing. Now the practice opens without revenue, but with commercial duties, and sometimes folks never really recover from that beginning. And then what happens, even if you get an early start, you fall behind. I see a lot of practices that end up selling their receivables in what's called a factoring relationship. It's kind of like a loan. against the receivables, but you're selling future receivables. When you look at the number, these are like payday loans for professionals. And I have a high number of folks that I see on a regular basis who engage in this process of factoring their receivables. They get the money today because they know that the money's going to be, or they think money's coming in later. And then if you have a glitch or a hiccup in that system, I've seen folks go out of business. Lab company a couple of years ago went out of business. I'm dealing with somebody else right now where they're in a lawsuit, and the lawsuit stems from the factoring relationship. The sequencing failure is a real issue. So let's talk about this before you start, or talk to a professional. I can connect you with folks, uh, and let's make your map and your plan before you start taking on especially financial obligations. Uh, Undefined scope, again, opening up and not really knowing what you're going to do. And the risk here is that if you don't do the analysis in the beginning, you could run into a situation with licensure. You end up providing services that don't fit within the license under which you're operating, or don't fit within an exemption that you think you're operating under. This is particularly applicable for nurse practitioners. Here's another issue. Let's say you're working as an independent practitioner under protocols of a physician, but your practice veers off. You didn't define it well in the beginning, and now you're running one type of practice, but the protocols suggest that you're running another type of practice. Or you've got the wrong person who's overseeing you've got a general practitioner instead of a specialist in the area where you're working, and and maybe you need to have a specialist overseeing your practice. So again, undefined scope of services can create a problem. And then, non-clinical ownership. Uh, this is where folks assume that the wholly owned exemption is going to apply when your structure doesn't qualify. And I've seen this, by the way, with structures, with business structures that are owned by physicians, where we normally run into the problem or see an issue that comes up is you've got a couple physicians, they've got a successful group practice, they're running it, they're hiring more people. Now they decide they maybe want to step away and they don't want to work in the practice full time, so they're going to step back. Maybe they bring in another investor or another partner into the mix. I've had two in the past year or two where we've had this big operations. They bring in another individual to oversee, or to be involved in the ownership, but they haven't considered that from a licensing perspective, that now by bringing in a non-qualified individual into the ownership structure, they now need to go get a license. Or there may be other reasons why you get licensed, even though it may not be absolutely necessary. And one distinct reason would be if you are, let's say, a physician and you want to own the practice, but you're not working in the practice day to day. You also want to own a lab, and you want to have maybe an MRI, and you want to be able to do referrals, but not be subject to the kickback rules or Stark rules. Sometimes if you're not the referring physician, you may not be subject to those rules. I'm not going to give you a hard, fast answer. This is a case by case analysis, but by being just the owner who owns both of these, and you have a physician who's working for you, or a PA who's working for you, who's making referrals for labs or MRIs, and they go to a facility that you also have an ownership interest in, it may be strategically better for you to, even though you could own the practice yourself under the exemption, it may be strategically better to have the license, because that gives you a clearer way to say, hey, I'm not the one providing the services. I'm not the one making the referral. And if I'm not making the referral, I'm not subject to the same restrictions that exist when you get into healthcare referrals. So again, these are things you really need to think about. And hopefully what we've talked about today is giving you a roadmap and giving you this foundation to sit down, you leave here and write out, what do you want to do? And then take that and we build the map off of that. So the practice model first in writing, before the entity, before the licensing, before the credentialing. All these things need to be mapped out so you get the timing right to make sure you've got income coming in. But we're going to put it all together and decide first, what is the practice that you want to operate? What's that look like? Who are your patients going to be? And then we build everything off of that. I mentioned earlier, what that might look like when you put it together. Another example, let's say you're going to be a cash pay hormone therapy practice owned by an advanced practice registered nurse. You do hormone optimization practice for adults age 35 to 65 in the Central Florida area. You operate as an autonomous practice, and You're going to start off on day one doing panel testing, testosterone replacement therapy. You're going to maybe you're initially you realize, okay, the services I'm providing are going to require a collaborating physician, so I'm going to collaborate with Mr. or Dr. So and so in order to provide these services. And then maybe define what you're not going to do. The practice is not going to accept insurance. The practice is not going to offer any type of aesthetic injectables. We're not going to provide weight loss medication or management on day one. Maybe these are things that you do later. Define that, draw out the paragraph, and then build off of that. And maybe let's set an appointment. I'm happy to talk. I talk to a lot of people about this. And then there's some other mechanisms too to help you on your path if this is what you're looking at. The way this stuff typically gets done is some people try to go it alone and answer questions, address questions as they come up. The problem there is you don't know what you don't know. That's always the issue. Is a lot of people just never realize that there's restrictions, even on the marketing piece. A lot of folks don't realize that you can't just go out and hire somebody to and pay them on a per patient basis. It's not like other industries where you can pay every time somebody is referred to you. The lawyers do that. You can't engage in fee splitting, but there's a lot of marketing companies out there, like for car accidents and so forth, stuff we don't do. But you can have paid marketing where you pay for every lead that gets sent to you. Healthcare, that's a big no-no. You really have to have a flat fee arrangement set up. So we define the model and build off of that. And what we typically see folks do here is you can engage the law firm, and I'm doing some of this right now, where we do each piece. We set up the entity structure. We often try to do that on flat fees. I'll do contracts for folks. We'll do the patient intake documents, the informed consents. We'll do the protocols, medical director agreements, and that you have an attorney-client relationship, but you need to budget it properly. And you need to expect that that's probably going to be, depending on the level of involvement from the attorney, you're going to spend, you really, in my view, should be budgeting somewhere between $15,000 to $25,000. You also need to have a good healthcare accountant. You need to have a good insurance advisor. And it really makes sense to work with a consultant to help guide you through these pieces unless you have a lot of time and a lot of familiarity on your own. And I mention these because we're actually, as we're doing these webinars, we're setting up a separate program that we'll be starting. We're going to do the first a demo or essentially a trial run of the program starting in the fall, and it's set up as a practice launch accelerator. It's going to be an 8-week cohort. It'll take people through every step that we talk about in setting up the practice from your model to your entity, provide you documents and examples and things that will help you on that path and give you a defined outcome once you go through that process. That's going to be at a much lower cost. It won't be legal services. It'll be a separate company that's providing those, but I'm assisting with that company. And they'll be providing an 8-week program that you can go through from start to finish, and you get a path, a clear path with homework assignments and deliverables, so that at the end of that process, you have everything you need to open up your healthcare practice. Both paths are available. Neither is required. Obviously, you can certainly do this stuff yourself, but I think it's useful for folks to understand what their options are. And obviously, if you do that, you're doing it, and it's not with a lawyer, just like I say with working with consultants, it's oftentimes much more economically efficient because it's somebody that's dedicated to just providing that service without any other distractions. And I think it's a much more efficient model for folks to work through to get where they need to or where they want to be at the end of the day to achieve your goals on owning your own practice. And as somebody who owns a law firm myself and took that step 12 years ago with my partner, there's nothing better than owning your own business. So I hope folks today maybe get a little bit of benefit out of this, both from a knowledge perspective. I don't intend to scare you, but I intend to inform you so you have clarity and hopefully maybe motivate you. It's not, people are doing this all the time. So if you're on the fence, really think hard about giving it a go. All right. Any other questions? What else can I answer for folks? Now is the time. You have there's the materials. If I think we circulated participant materials for today. You'll see there's several legal citations in there for the statutes and rules where you can go read about some of this stuff yourself. I always welcome questions from folks. You can email or call the office, set up an appointment, and we can work from there. Thank you very much for joining today, and good luck in your endeavors going forward. And look out for further notices that will track the series that we are starting on building your own healthcare practice and walk you through all of these the what and why of all of those steps. And have a great rest of your day.